I want to quickly talk to you about the IRS Form 56. And here's an overview I want you to pay attention to. So when we think about Form 56 here, I want you to look right now on the screen. This is basically the official title of the form here is Notice Concerning Fiduciary Relationship. Notice Concerning Fiduciary Relationship. And so basically you have part one. In part one, you have to put the anything that relates to your identification. So you put the first name and last name, your identifying number. So this could be your social security number also, and also you have to put the decedent's social security number as well. And so you have to put the address, the fiduciary name, and zip code and everything. So you have to put the telephone number also, just in case the IRS has to rate you. This is really important. So one thing I want to say here is that it's all about transparency. You want to provide the proper information so that the IRS can contact you should the need arise. And so this is the part one. So part one, you have section 8, authority. So here you have to specify what kind of authority you have, because see, remember when we talk about fiduciary relationship, you have a variety of relationship, I would say a context here, and you have to specify what it is. So you have a court appointment of a tested estate. So in other words, a valid will exists, and this is what we chose for our hypothetical example. But you have other options. You have from B all the way to G. You have here court appointment of interstate estates. In other words, no valid will exists. You have court appointment as guardian or conservator, fiduciary of interstate estates, valid trust instruments and amendments. You have bankruptcy or assignments for the benefits of creditors. So the bottom line here is you have a constellation of options that really can show you what really matters here. One thing I want to say here is that part one is pretty straightforward. So part one, section A, authority, A, straightforward. Now line 2A, as you can see on the screen here, you have to put the date of the death. Again, when we talk about 56, we're speaking about a death here. So that you have to put the date of the death, and this is pretty straightforward. So this is section A. What about section B? Section B, you have the nature of the liability and tax notices. So here you have to type you have to actually indicate all the type of taxes. So in our case here, we actually applied for everything. So income, gift, estate, generation, skip and transfer, and employment taxes. And so this is for line 3. Line 4, you have federal tax forms. So you have to check all that apply. So here we just checked 941, 943, and 944. And also 1041 and 1120. 1120, that relates to the C corporation, okay? And so line 5 also, if this line 5 applies to your case, you have to check the appropriate form. If not, not a problem. By the way, boss, welcome back to the show. It's really a pleasure to have you here. Make yourself comfortable. You are going to enjoy today's conversation. So let's talk about part 2 here. When we talk about part 2, this is a revocation or termination of notice. It's one of those things where you have to be pretty clear as to what works for you and what doesn't work for you. And so basically here, I put it here, this might not apply to your situation, but I put it here anyway so that you have a clear idea of what I'm speaking about. And so you want to check this box if you are revoking or terminating all prior notices. So this is part 2. Part 3 is pretty straightforward also. Part 3 is actually has to do with court and administrative proceedings. So if this applies to you, not a problem. And part 4 actually is applicable to all situations. This is where you have to sign. So when you file Form 56, you always have to sign. You have to sign the form and also date it. It's really important. And in some cases, you have to put the title if applicable. If you have a specific title that really will sort of contextualize your filing, then you have to really specify here. If not, that's not a problem. One thing I want to say here is that when we talk about Form 56, this is actually at the federal level. There are some state consequences, of course, but this is actually this is a federal tax form. But you have to make sure the states where the death occurred and also the state where your fiduciary relationship originated. You have to, whether you have an interstate or when you want to have with a kind of valid will, if it exists or doesn't exist, you have to see that you want to make sure that state tax laws are actually followed through as well. Otherwise, you'll get in trouble. So bottom line here is that you want to see that you want to make sure that you file this form as soon as possible within regulatory requirements. By the way, boss, I want to quickly remind you of today's topic. We are having a conversation about Form 56, and this is a walkthrough of that form. I want to give you a few pro tips here. So when we talk about IRS Tax Form 56, and again, this is notice concerning fiduciary relationship, you have to understand that when we talk about Form 56, the purpose is pretty straightforward. IRS Form 56 allows the fiduciary to designate their authority rather, such as whether they have the power to receive notices and correspond with the IRS on behalf of the taxpayer. This is important because the IRS will direct communications and correspondence related to the taxpayer's affairs to the designated fiduciary, okay? And it's one of those things where when we talk about 56, you need to understand this form includes information such as the name and taxpayer identification number of the individual or entity for whom the fiduciary is acting, the type of fiduciary relationship, and the fiduciary's contact information. And so when we talk about Form 56, there are several sections. You have a section, so you have the identifying information. So here you have to talk about the name, address, and taxpayer identification number of the entity for which the fiduciary is being appointed. And you also have to put the name, address, and a TIN, so there's the tax identification number of the fiduciary or representative being appointed. And now you have to talk about the entity information itself. So this section requires information about the entity for which the fiduciary is being appointed, including the type of entity. So if you're having an estate, a trust, or whatever you can think about, the date of creation or the establishment of the entity, the purpose or reason for the appointment of the fiduciary, and if you have additional information that can be given about the entity, that's really also could be helpful. For instance, we are talking about the principal address, and also now the IRS wants you to go a little granular in terms of the fiduciary information. So this section contains information about the fiduciary or representative being appointed, including the relationship to the entity. So, for example, are we talking about the executor, the trustee, for instance, the date of the appointment as fiduciary? This is an important element. The mailing address, and this is different from the entity's address. The contact information, including telephone number and email address, and notices and statements. I think I showed you a little earlier that you have a series of notices and statements that could be directed to the fiduciary depending upon the certification. And finally, you have to have the certification and signature also. Now, let me talk to you a little bit about the benefits of filing Form 56, because when we talk about filing Form 56, we are trying to contextualize a lot of things vis-a-vis the IRS. First of all, you are able to ensure proper tax administration. You are protecting the interest of the taxpayers. This is really important. The IRS cares a lot about that. You have a form that facilitates communication with the IRS. You are able to avoid penalties and compliance issues. You are able to provide legal protection, and you are able to have a system whereby you are having tax refund processing. So let's really dig a little deeper here. So when we talk about ensuring proper tax administration, you need to understand, by filing Form 56, you are not only informing the IRS by the appointment of a fiduciary, but you're also telling the IRS that you are contextualizing the whole communication going forward. So when we talk about a fiduciary, we are talking about a party that will be responsible for handling the tax matters on behalf of the individual or entity. This helps ensure that the tax obligations are properly administered and addressed. And in terms of protection of the interest of the taxpayer, if an individual becomes incapacitated, or let's say is unable to handle his or her own tax affairs, filing Form 56 allows a trusted fiduciary to step in and manage his or her tax matters. And this actually, when you think about it, protects the interest of the taxpayer and helps ensure that his or her taxes are handled appropriately. You want to have a communication process that's smooth with the IRS, because the IRS, once Form 56 is filed, will recognize the fiduciary as the point of contact for tax matters. So this simplifies communication between the fiduciary and the IRS, allowing for efficient handling of tax-related issues, inquiries, and notifications. This is kind of important. And also, by appointing a fiduciary and filing Form 56, you establish a clear line of responsibility for tax matters. That way you can actually avoid some issues. And so this really reduces the risks of missing deadlines, late filings, or other compliance issues that could result in penalties or legal complications. So this is kind of important. Boss, I want to quickly remind you of today's topic. We are having a conversation about Form 56. Let's dig a little deeper here when we talk about eligibility. So when we talk about Form 56, let's talk about the eligible parties. So there are a lot of situations where individuals or entities may be eligible to file a Form 56. And so, for instance, let's say you have trustees of a trust, you have guardians or conservator, you have court-appointed representatives. So when we talk about, you also have, in some cases, everything depends on the situation and also the states where we are talking about. Okay, but those three categories are pretty much interesting. And you also have the executors or administrators of an estate. So when someone passes away, their estates may need to go through probate, and the executor or administrator appointed by the court to handle the estate affairs may file Form 56 to notify the IRS of their fiduciary role. And also you have trustees of a trust. So if you are appointed as a trustee of a trust, whether it is a revocable living trust or an irrevocable trust, you may need to file Form 56 to inform the IRS of your fiduciary position and take responsibility for the trust's tax obligations. And also this situation can apply to guardians or conservators. So if you have been appointed as a guardian or conservator for a minor or incapacitated person, you may file Form 56 to establish your fiduciary relationship and handle his or her financial affairs. And also in some cases, in some legal cases, the court may appoint a representative, such as a receiver or a personal representative, to manage the financial matters of an individual or entity. And the thing is that the court-appointed representative may have to file Form 56 to notify the IRS of his or her appointment. So one thing I want to say here is that you need to understand, filing Form 56 does not necessarily mean that you are required to pay taxes on behalf of the person or entity you represent. It is primarily a notification to the IRS of your fiduciary role, and this allows the IRS to correspond with you regarding tax matters related to the estate, trust, or individual you actually represent. So this is kind of you're trying to officialize things here. And so when should the IRS Form 56 be filed? It really depends. You can utilize Form 56 for the following purposes: notify the IRS of the establishment or termination of a fiduciary relationship under Section 6903, or you can also provide a notice of a qualification under Section 6036. And when it comes to when and where to file Form 56, it really depends. So you want to file this form if you want to establish a fiduciary relationship or proceedings and assignments, or also if you are a receiver or assignee. It really depends upon the situation that really applies to your case here. To really follow when it comes to a Form 56. Now, first of all, you want to obtain the form, so you can download the form from the IRS official websites. We're speaking about irs.gov, or you can request a copy by calling the IRS forms at 1-800-829-3676. So this is pretty straightforward. You want to read the instructions. Always read the instructions. So we're talking here about you going through the form itself, the most updated version of the form. You want to enter your personal information, including your name, address, and taxpayer identification number. So here we are speaking about what really, if you are an organization, You want to provide the organization's name and EIN so that you have a clear idea what's really happening. And you want to identify the fiduciary, okay? And so you want to provide information about the fiduciary relationship. So we're speaking about the name of the estate, trust, or organization, and the date it was created or terminated. You want to indicate whether you are the fiduciary or the responsible party. So it's one of those things where you have to clarify what really works in your case. One thing I want to say here is that you also need to identify the type of fiduciary relationship, or also the type of fiduciary entity. So again, we are speaking about estate, trust, or other, and you want to choose the applicable codes. Every fiduciary relationship triggers a certain code, and you probably saw that on the Form 56 itself. So you want to check the box that indicates the reason for filing Form 56, and you want to provide additional information depending on your situation. And it's one of those things where you are trying to contextualize the relationship for the IRS so that the agency has a clear idea about your role here. And please do not forget to sign and date the form, because otherwise the IRS will not process the form for you. So sign and date the form so the IRS knows exactly what's really happening, and you want to keep a copy. Keep a copy of the completed Form 56 for your records. You want to send the original form to the appropriate IRS office based on your location, and the address to which you should send the form can be found in the instructions. And again, everything depends upon the states you are actually filing from. And also there are certain, it also depends on the specific type of fiduciary relationship you're trying to establish. Now let's close to this conversation by giving you a few special considerations when filing Form 56. You really have to pay attention to accurate and complete information. You want to pay attention to timeliness. This is kind of important in terms of helping you knowing exactly what really matters, and also supporting documentation. So in some cases, supporting documentation may be required to accompany Form 56. For example, if the fiduciary relationship is created by a court order, a copy of the order should be attached to the form. And so this is important because otherwise the IRS will not process the request for you. And so when we talk about the accurate and complete information, you want to actually double check everything so that you are avoiding errors or delays in the processing. And also, if there are multiple fiduciaries, if you have more than one fiduciary for the same taxpayer, each fiduciary must file a separate Form 56. You want to provide accurate information for each fiduciary involved to avoid confusion or processing errors. And there are other tax forms that also could be applicable here. So filing Form 56 does not relieve the fiduciary from other tax filing obligations. So depending on the specific circumstances, the fiduciary may still need to file other tax forms, such as the Form 1041. So this is actually U.S. tax return for estates and trusts, or Form 706, U.S. estates and generation skip and transfer tax return. So this is kind of important. So you always want to be aware of the additional requirements and ensure compliance with all applicable tax filings. And also you want to pay attention to updates and changes. So if there are any changes to the information provided on Form 56 after filing, such as, let's say, a change in the address or termination of the fiduciary relationship, you want to notify the IRS promptly. Do not wait, because otherwise you'll be wasting a lot of time, and you could expose yourself to some penalties. So there are some common mistakes you want to avoid when filing Form 56: incomplete or incorrect information, failure to attach the necessary documentation, failure to select the correct box. This happens a lot, so you want to really make sure that you do not actually have that problem. Failing to select the correct box is really incorrect mailing address also. Failure to notify the IRS of changes, and neglecting to keep copies for your records. You always have to keep copies for your records. Very important. Thank you so much for your attention. I really appreciate it. Let's do a quick recap here. So in today's conversation, I spoke to you about Form 56. So I gave you the overview, the pro tips, the steps, and now the recap. Thank you so much. God bless you. I'll see you next time. Until then, remember, stay Marvelous.